Jeremy, it's time to shoot legal briefs.
I can't do it today. There's just no way.
What's wrong?
I mean, I don't have an opening, plus to make matters worse, I feel like such an idiot. I mean, look at this. I wanted to bring in another crypto YouTuber, like we did with John Deaton and those guys a couple weeks ago, which was awesome, and I wanted it to be a surprise, so I reached out to BitBoy himself on Twitter, and I threw myself out there like a young, love-struck girl, and BitBoy didn't respond to me at all. And I know he read it because you could see the check down there at the bottom. He completely ghosted me.
Well, technically, Jeremy, in order to be ghosted, he actually had to have responded in the first place.
This is humiliating. Give me the camera.
Welcome to Legal Briefs, XRP edition. This is Attorney Thien-Vu Hogan, and this last week in the Ripple versus SEC case, we had not one, but two orders come down from Judge Netburn. And there was some good news and there was some bad news. Which do you want to hear first? So Jeremy usually gives you the bad news first so that you'll watch the rest of the video to get to the good news. But I'm not going to play that game with you. Instead, let's start with the good news and leave the bad news for last. On Thursday, the judge in the Ripple case issued an order on two pending discovery motions. Yes, it was a 2-for-1 day. And let's start with the first part, which was the good news. Quote, first, defendants Ripple and Christian Larson moved to compel the SEC to supplement its responses to 11 of Ripple's interrogatories and 2 of Larson's. Close quote. So you may recall Ripple served numerous questions to the SEC a couple of months ago called interrogatories, and the SEC refused or failed to answer almost every question. So Ripple asked the court to force the SEC to answer, and the good news is in the very first interrogatory question and in the 6th. The first interrogatory really gets to the heart of the case and asks as to each of the 1,500 contracts involving the sale of XRP that took place from 2013 to 2021. Quote, Ripple moves to compel the SEC to identify all terms of the contract that the SEC contends created an expectation of profits for each contract the SEC listed in response to a previous interrogatory. Close quote. This question really gets to the heart of the matter because for XRP to be a security, there must have been an investment contract, an agreement where people bought XRP in exchange for a promise by Ripple that it would work to increase the price of XRP for the benefit of the purchaser. And the problem for the SEC here is that you out there watching, if you own XRP when you bought it, you had no agreement with Ripple that it would work for you. In fact, the contracts that are referenced in this interrogatory, we haven't even seen yet. But I would be shocked if any of them are between Ripple and, let's say, John Smith from Little Rock, Arkansas. Instead, these contracts are between Ripple and other businesses. So as we discussed in other videos, the SEC is going to be forced to argue that Ripple marketed to retail purchasers as though there was an investment contract. It's a circumstantial case. But the SEC didn't want to come out and just say that. So Judge Netburn is forcing the SEC's hand, and here is what she orders. Quote, the SEC opposes on the grounds that the interrogatory assumes, by its lights, an incorrect reading of applicable law, and that the contours of investment contracts under Howey need not come from contracts alone. The SEC's legal theory is not an excuse to avoid responding to defendants' factual inquiry, nor is it a basis to answer a different question than posed. Ripple's interrogatory is relevant and precise and will clarify whether the SEC contends that the terms of any contract identified in response to Ripple's interrogatories number 1 created an expectation of profits by the purchaser of XRP. Accordingly, defendant's motion regarding Ripple's interrogatory number 2 is granted. Close quote. And with that being said, the SEC being forced to address all 1,500 sales contracts, the SEC is now put in a tough position. It either has to admit there is nothing in writing in the contracts that form an investment contract, and therefore admitting that its case is all circumstantial, or it can go through each and every contract and try and find something in the contracts that somehow ties Ripple to people who bought XRP on Coinbase last year. My instinct is that the SEC won't try and go down that road and will instead concede that it is bringing a marketing case. That's similar to a prosecution in a murder case having to admit that its case is based on the defendant having motive and the means to kill the victim, but not really having any hard evidence of guilt. No fingerprints, no eyewitnesses. You can win that case, but it isn't the easiest way to win. And the second piece of good news is in the 6th interrogatory, which asked the question, as paraphrased by the court, quote, whether the XRP ledger was not fully functional before the start of the ongoing securities offering alleged in the complaint. And if that is the SEC's contention, identify when the SEC contends the XRP did become fully functional, if ever, and what actions or efforts resulted in making the XRP ledger fully function. Close quote. And the judge orders that the parties meet and confer as to what is meant by functional. And once Ripple clears that up, the SEC must answer, and that is good for Ripple. But what is even better is this from the court. Quote, defendants counter that the SEC's own public-facing website states that whether a digital asset is not fully functional at the time of the offer or sale is relevant in a Howey analysis. The court argues that this interrogatory seeks relevant information. Close quote. So hidden in the weaves, we find a gem. So basically, on the SEC's website, it actually says that whether a blockchain is fully functional is relevant to the Howey analysis. And that is something that the SEC has been trying to deny this entire litigation. And this is basically what Hinman said in his infamous Ethereum is not a security speech. And the SEC has bent over backwards to say that's not an official SEC position. And by the judge saying that information is relevant, she is basically signaling that it doesn't matter what the SEC says. The court thinks that it is relevant and it is going to take that into account. And that is some good news, actually really, really good news. And now, unfortunately, for the bad news. In the same order we just looked at, the judge ruled on the SEC's motion to strike all Ripple's requests for admissions. There were over 29,000 of them. And here's what we thought about that from 2 videos ago.
And that is our area of conflict here because Ripple served over 29,000 RFAs on the SEC, and the SEC did not like it one bit because, as the SEC complains, quote, these requests impose an extreme burden on the SEC, specifically if a single SEC attorney spent an average of only 5 minutes reading and answering each request, it would require 104 days to respond, close quote. Now, I think that argument will be compelling to the judge, and the SEC has a lot of case authority to cite for the proposition that even hundreds of RFAs are too much. So, in brief, I feel like Ripple didn't take this one home like they normally do, and I think they leave themselves open to having the number of RFAs from 29,000 trimmed down to some lesser number by the judge. But even if you see an order to that effect in the next couple weeks, which grants the SEC's motion, don't lose sleep about it because it doesn't limit Ripple's evidence. It will just force Ripple to present the evidence instead of having it all admitted as an RFA.
And yes, that was 1,000% spot on because here is what the judge says in the order. Quote, the SEC posits that if one staff attorney spent only 5 minutes reviewing and answering each request without breaks or sleep, it would require nearly 104 days to respond. Close quote. So the judge did exactly what Jeremy expected. You can call him Judge Jeremy. And even for the same reasons. So that was expected. But what we did not expect was in the final order and the worst news for XRP holders. And that was the order on the SEC's second motion to extend discovery. And here was the request filed on October 15. Quote, Plaintiffs' Securities and Exchange Commission respectfully requests the court extend the expert rebuttal report deadline to November 12, 2021 and the expert discovery deadline from November 12, 2021 to January 14, 2022 to permit the parties sufficient time to prepare rebuttal reports and depose a minimum of 14 expert witnesses, close quote. And Ripple opposed this and tried to limit the length of the extension, but the judge granted the order and extended expert discovery out to mid-January, which can only hurt Ripple. But also reading between the lines, we can also see that this court moves at its own pace, no matter what a party like Ripple may want. For example, in most courts that I'm in, motions to strike affirmative defenses or to dismiss complaints are dealt with right away, so the parties know what the pleadings are going into discovery. This court still hasn't even dealt with these motions, and that seems to be the way it's going to do it. Slowly and at its own pace. And what does that mean? It means that absent a settlement, this case will not be decided now until March 2022 at the earliest, and possibly not even until late spring of 2022 if the court decides not to rule on some of the pending motions until after the discovery deadline, which looks really possible. So buckle up, this could go on for the distance. Thanks for watching.
Wow, how cool is that? I just messaged a Rothschild. Who needs BitBoy after all?